I've seen witnesses break down on the stand before, tears streaming, voices cracking mid-sentence, long, awkward pauses, searching for words. But what happened in federal court yesterday afternoon was unlike anything I've witnessed in 3 decades of prosecuting cases. This was not ordinary stress, not the typical anxiety under cross-examination. This was a complete psychological collapse, a total, unflinching, undeniable breakdown. A bank executive sat in the witness box, documents spread across the table in front of him, pages stacked like confessions, every spreadsheet, every margin note, every initial staring back at him like an indictment. And in that moment, he realized what he had done. He had falsified everything. And right there in open court with the jury watching, he broke, but not in the ways people expect. No tears, no dramatic shouting, no sudden outburst, just a shutdown so complete it was chilling. His hands froze midair, suspended between denial and confession, eyes locked on the pages, unblinking, every muscle in his body rigid, as if his mind had pressed pause on reality, the kind of break that doesn't just reveal stress, it reveals total awareness of defeat, the awareness that every defense, every argument, every carefully constructed alibi had evaporated. It was terrifying and mesmerizing all at once. You could feel the courtroom holding its breath. Observers leaned forward instinctively, as if not moving would somehow keep the moment intact. Lawyers froze, pens hovering over notes. The judge's gavel felt heavier in the air, the silence stretching longer with every passing second. Nothing moved for what felt like minutes. Then, slowly, the executive began to speak, not with clarity at first, but with the measured, trembling admission of someone who understands they have no escape. He walked the jury through years of loans, valuations, approvals, and notes. Each admission fell like a hammer on the case. Each detail tied the defendant directly to the scheme. And yet, even as he talked, the memory of that first moment, the freeze, the paralysis lingered. That was the point where the truth hit him with full force. That was the instant where the safety net of routine, hierarchy, and procedure vanished, leaving him exposed to the raw reality of his own actions. The courtroom remained silent. You could almost hear the collective heartbeat of the people inside. Reporters scribbled furiously, capturing the rhythm of a collapse that was both human and damning. Jury members leaned forward as if proximity could somehow absorb the truth more quickly. This was more than testimony, it was revelation. It was the moment when a system of deception, trust, and convenience finally met the immovable wall of accountability. And it began not with words, but with stillness, a complete, unyielding human pause that signaled the end of denial. In federal court yesterday, the witness didn't just testify, he imploded. And in that implosion, the prosecution found what it had needed all along, a living, breathing acknowledgement that the papers didn't lie, and neither could he. I have seen this before in interrogation rooms. I have seen it during painstaking interviews where law enforcement corners a suspect, but never in open court, never on the witness stand with a jury, public scrutiny, and a defendant waiting for his fate. The prosecutor had asked a simple, almost casual question. Mr. Harrison, are these your initials on the approval documents? The witness looked down, stared at the papers, jaw clenched. You could see him calculating. Could he lie? Could he explain it away? And then after what felt like an eternity, but was probably only 15 seconds, he made his choice. 5 words. 5 words that ended the trial before it could even reach its conclusion. I falsified everything for him. The courtroom went silent. The defense attorney's face turned pale. The judge leaned forward, trying to process the magnitude of what had just been said. And the prosecutor, calm, composed, professional, asked the only follow-up question that truly mattered. When you say everything, what do you mean? And that's when the executive started talking. He did not stop. 47 minutes of uninterrupted, devastating testimony followed. Here's what you need to understand about this case. The defendant had been on trial for bank fraud, specifically allegations that financial statements submitted to secure loans contained false valuations. The prosecution had built a mountain of circumstantial evidence, emails, documents, bank records, but nothing that directly tied the defendant's hands to the falsifications. Every connection had to be imagined, pieced together in the jury's mind. Circumstantial evidence is powerful, but it lacks the punch of a first-hand account. That's where the bank executive came in. He had been the senior vice president at the lending institution. He approved the loans. He reviewed the financial statements. And according to his own testimony, he helped create the false documents. The prosecution had called him as a hostile witness, expecting minor admissions, confirmations that the documents were authentic, maybe a reluctant acknowledgement that some valuations were high. But nothing prepared them or anyone in that courtroom for what happened next. The prosecutor slid the documents across the table and asked him to confirm his initials. That's when the air changed. You could feel it. Shoulders dropped ever so slightly. Breathing shifted, subtle but unmistakable. The executive paused. His eyes lingered on the pages. It was a conscious decision, almost imperceptible, yet monumental. In that split second, he chose truth over silence. The documents were not just paper, they were proof, fingerprints of complicity, traces of decisions made and recorded. Every initial, every margin note, every line of handwritten text tied him to the actions the defendant had orchestrated. And now, under oath, he began to speak, slowly at first, carefully, every word is measured. He described how the defendant had been considered a good client, trusted, reliable, untouchable on paper. But appraisals often came back lower than the claimed valuations. Every discrepancy had been discussed. Every inflated number had been accepted, approved, initiated. He explained the methodical process: phone calls, conversations, verbal confirmations, numbers adjusted, loans approved, favorable financing maintained, performance targets hit, bonuses earned, promotions secured, recognition accumulated, all of it tied to decisions documented in the margins of financial statements in the faint ink of his initials. The courtroom held its collective breath. Observers leaned in, lawyers scribbled frantically, reporters paused, sensing they were witnessing the fracture of a carefully maintained illusion. The witness was no longer just confirming facts, he was illuminating intent, revealing process, and dismantling defenses with the weight of lived experience. The executive's testimony connected dots the prosecution couldn't tie with emails or spreadsheets alone. Circumstantial evidence became concrete. The defendant's advantage, once abstract, became tangible. 14 loans, nearly $2 billion in value, $200 million in interest savings. Every number, every approval, every initial formed a chain pointing directly to calculated, deliberate wrongdoing. And it all started with a single conscious decision: to tell the truth. That moment transformed the trial. It shifted the momentum. It turned speculation into certainty, and it sent a clear message: even the most carefully constructed empire of paper, prestige, and influence could crumble under the weight of honesty. The courtroom watched history unfold, one signature, one note, one admission at a time. I've seen cooperative witnesses before, people who cut deals, people who trade testimony for immunity or reduced sentences. But this was different. This executive hadn't made a deal. He hadn't been charged. He wasn't testifying to save himself. He was sitting there under subpoena as a bank employee, facing facts he couldn't deny. And yet, when the weight of evidence hit him, he made a choice. Lying was no longer worth it. The documents on the table told the story. Loan approval files from 2019 through 2022, stacked in neat piles, each one a thread in a web of deception. Financial statements for the defendant's properties, reviewed and signed off in the usual way. But the usual way was only part of the story. Margins were filled with initials, the executive's initials, a standard procedure, yes, but then came the notes. Handwritten, precise, damning. Appraisal came in lower, used client's valuation instead, confirmed with client, numbers needed for approval. Initialed, signed, verified. Each note was a fingerprint of complicity, not a casual scribble, not a shrug of oversight. Every line showed intent, awareness, and a deliberate bending of rules. The documents didn't just prove he reviewed them, they proved he made the decisions. The courtroom was silent, the air heavy with anticipation. Observers leaned forward, lawyers scribbled furiously, reporters paused mid-take, sensing they were witnessing a rare crack in a fortress of corporate loyalty. And there he was, a man with nothing to gain but integrity, admitting truth in a moment that could upend everything. Each word he spoke carried weight, each acknowledgement a hammer striking at a carefully constructed empire. The implication was stark. This wasn't a witness hedging for advantage. This was someone confronting his own actions, finally acknowledging what everyone else could see on paper. The decisions had been deliberate, the cover-up meticulous, and the responsibility undeniable. Every note, every initial, every carefully phrased confirmation became a thread the prosecution could pull. And as the courtroom absorbed the gravity, it was clear this testimony was a pivot point. One man's choice to tell the truth could unravel years of calculated deception. Silence stretched, pens hovered. The defendant shifted in his seat, and the executive, ordinary in appearance but extraordinary in consequence, leaned into the truth he had been avoiding. The room held its breath. History in that moment was being rewritten in ink and initials. When the prosecutor asked him to explain the notes, the executive didn't rush. He paused, deliberate, careful, every word measured. He admitted the truth, layer by layer. The defendant wasn't just any client. He had long-standing relationships with the bank, multiple loans, always on time. A good client, the executive called him, trusted, reliable, untouchable, at least on paper. But the documents told a different story. Appraisals came back lower than the valuations listed in the financial statements, numbers that didn't add up, yet somehow the loans were approved. The executive explained how it happened, the calls, the conversations, the decisions made behind closed doors. When a discrepancy appeared, he would pick up the phone. The defendant would answer. They would discuss the gap, market conditions, unique property features, development potential, stories that made sense, at least on the surface. And the executive, for reasons that were part business, part trust, part pressure, accepted it. He approved the loans using the client's inflated valuations. Each approval initialed, each note recorded, every step documented, a paper trail that tied him directly to the scheme. It wasn't coercion, he insisted. It wasn't a mistake. It was a deliberate choice, a decision made to protect a client the bank valued, to keep loans flowing, to maintain appearances. The courtroom was tense. Every person listening felt the weight of the confession. This wasn't abstract fraud. It was a meticulous human process of bending rules for influence, for relationships, for power, and just like that, the executive became a linchpin. His testimony linked the defendant directly to the loans, the inflated numbers, and the deliberate decisions. A web of complicity, once hidden in spreadsheets and margins, now exposed under the harsh light of legal scrutiny. Silence fell again. Pens hovered. Cameras captured every expression. Every word he spoke tightened the net around the defendant, revealing a system of favors, trust, and calculated risk that had long gone unchallenged. That testimony alone was devastating. It showed that the defendant knew the appraisals were lower, that he actively justified higher numbers, and that the bank willingly ignored the true figures. But the crucial moment came when the prosecutor asked the executive, "Did you believe these explanations?" He hesitated, then said, "No." He knew the valuations were inflated, but the defendant was a major client. The bank made significant money on the loans, and the executive was under pressure to approve deals. And then came the piece of evidence that shattered any remaining defense. An email from the defendant to the executive, subject line, "Financial statement for refinancing." The email read, "I need the property valued at $400 million to meet the loan-to-value ratio. The appraisal came in at $215 million, but we both know appraisers undervalue properties. Can you work with my number?" The executive confirmed he received the email, and yes, he approved the loan using the $400 million valuation, but it didn't stop there. The prosecutor then produced a draft version of the financial statement that the executive thought had been destroyed. On that draft, someone had crossed out $215 million and written $400 million above it. The handwriting, the defendant's. The executive had seen the draft, the defendant had shown it to him during a meeting and asked him to accept the higher valuation. And then came the question that broke him. Did the defendant tell you to falsify the final version, to remove any reference to the $215 million appraisal? He closed his eyes, took a breath, and admitted, "Yes, I falsified everything for him. Not just that one document, everything. For years, multiple properties, multiple loans, patterns that repeated like clockwork, hidden in plain sight, buried in the margins of financial statements. Every time an appraisal came back lower than the claimed valuation, the defendant and the executive acted in tandem. They made sure the bank only ever saw the higher number. It wasn't sloppy bookkeeping. It wasn't a casual oversight. It was deliberate, calculated, methodical. The executive would initial the approval. The loan would sail through the bank system, untouched by scrutiny. And the defendant, he maintained favorable financing, a steady stream of advantage tucked quietly into the fine print. The system was simple, elegant, and ruthlessly effective. The defendant kept his business flowing to the bank. In return, the executive kept hitting his performance targets. Bonuses, promotions, recognition. Every step reinforced the cycle. Every signature, every note, a gear and a machine designed to reward loyalty and wealth above integrity. When the prosecutor asked how many loans were involved, the executive's answer sent a ripple through the courtroom. At least 14 separate loans totaling nearly $2 billion in value, numbers that were almost incomprehensible yet painfully real. And the benefit? The defendant saved approximately $200 million in interest over the life of those loans. $200 million gained not through risk, not through innovation, but through careful, deliberate manipulation. Every dollar traced back to a single pattern of decisions, a chain of initials and notes that proved awareness and intent. The room was silent, observers leaned forward, lawyers scribbled furiously, reporters shifted in their seats, pens poised above notebooks. Each person understood the magnitude. This wasn't just fraud, It was systemic. It was sustained. It was engineered to reward influence and power at every step. The executive described the mechanics calmly, almost clinically, but each word landed like a hammer striking the foundation of a towering structure. Calls made, explanations accepted, approvals signed. Every margin note, every initial, every verbal confirmation reinforced a cycle that had gone unchallenged for years. It wasn't a conspiracy in the shadows. It was ordinary business practices twisted into something extraordinary. It was compliance turned complicity. A single executive's decision-making process, replicated across multiple loans and properties, had created a fortune for one man while leaving the institution exposed to unimaginable risk. And yet, even with all the documents, all the approvals, and all the evidence laid bare, the executive's testimony carried a human weight. He hadn't been forced. He hadn't been promised anything. He had simply decided that the truth was the only thing worth telling. And in that choice, the prosecution suddenly had a linchpin, a living, breathing witness who could connect the dots between intent, action, and outcome. Every number, every loan, every note became a story of ambition, greed, and meticulous planning. The scheme was no longer abstract. It was tangible. Every dollar saved, every signature placed, every appraisal adjusted, visible. And the consequences were stark. Nearly $2 billion in loans, $200 million in advantage, and a defendant whose empire had been propped up by orchestrated deception for years. The courtroom hung on every word, understanding that the revelation wasn't just financial, it was moral. Every system in place to prevent such manipulation had been circumvented, every safeguard ignored, and the implications rippled far beyond the bank. This wasn't just testimony, it was the unraveling of a carefully maintained illusion, exposed in real time, under subpoena, under scrutiny, and under the unforgiving gaze of law. Legally, this testimony nailed every element of bank fraud. False statements made to a financial institution, check. The defendant knew the statements were false, check. Intent to deceive, check. Materiality, the loans wouldn't have been approved without the inflated numbers, check. But it got worse for the defendant. The executive also testified about multiple meetings where they discussed the scheme. He recalled conversations in 2020. The banks never verify these numbers. As long as we're consistent, nobody asks questions. Another in 2021. If this ever comes out, you'll say you relied on my representations. I'll say I relied on my accountants. Nobody goes down. These statements show consciousness of guilt. The defendant knew he was committing fraud and had a plan to avoid consequences. The defense tried to cross-examine. Isn't it true you initiated some of these loans yourself? Yes. Isn't it true you profited? Yes. So you're blaming my client? That's when the executive sealed it. I made decisions, bad decisions, but I made them because your client told me exactly what numbers he needed and why. He showed me the draft documents. I'm guilty, and so is he. The answer was simple. The executive admitted personal wrongdoing without a deal, without protection, without incentive. That's the gold standard for juries. It's a confession that is impossible to doubt. The prosecutor asked one final piercing question. Knowing what you know now, do you believe the defendant intentionally defrauded the bank? The executive looked directly at the defendant for the first time. Yes, he knew exactly what he was doing, and so did I. And I'm sorry I helped him do it. The judge called a recess immediately after that testimony. When court resumed, the defense rested without calling a single witness. What could they say? Their expert valuations could not overcome a bank executive confessing to falsifying documents at the defendant's direction. The defendant refused to testify, knowing the executive would destroy him on cross-examination. The jury had heard everything: insider testimony, emails, financial documents, draft statements, personal admissions of falsification, and conscious intent to defraud. The case was over. Closing arguments would only formalize what was already clear: guilt beyond a reasonable doubt. When sentencing occurs, the $200 million in fraudulent benefits will likely place the defendant at the highest end of the federal guidelines, facing 15, 20 years in prison, possibly more if aggravating factors are considered. The executive, he may also face charges. No immunity was granted, yet by confessing in court, he chose truth over self-preservation, accepting the consequences of his actions. That decision devastated the defendant, who had relied on his silence for years. This case will be a teaching example: why banks must independently verify valuations, why co-conspirators cannot be trusted when the evidence becomes overwhelming, and why insider testimony can end a trial in minutes. So let me ask you, when a co-conspirator breaks and confesses everything in open court, is there any defense left? Think about it. Every angle the defense might have used evaporates when someone inside the scheme admits guilt and implicates the defendant without incentive or deal. It is the ultimate courtroom collapse, and yesterday we witnessed it in real time.